Good day. My name is Thomas Minnie and I'm a senior practicing attorney at Thomas Minnie Attorneys in Pretoria. For those of you who tuned into my last broadcast, welcome back. And for all the new viewers, welcome to you too. As you will recall, the last broadcast we dealt with the issue of residential lease agreements and specifically against the background of the COVID-19 lockdown. Today we'll be having a look at commercial lease agreements. You will then see that there are some subtle differences between the issue regarding residential lease agreements and those of a commercial nature. You will recall we touched on the principle of vis major or force majeure. We'll be discussing that again, but against the background of the commercial lease agreements. Now, as with the residential lease agreement, the first port of call must be a written agreement in the event that there is such an agreement. These agreements usually contain a clause dealing with the manner in which the contract must be dealt with when the issue of force majeure arises. From the outset, it is important to realize that the main difference between a lease agreement of a residential property and a lease agreement of a commercial property lies in the rights available to the various parties. Now, when we discussed the residential property, we touched on the aspect of whether or not the court would be compassionate to a landlord who seeks to evict a resident that finds himself in an unfortunate position as a result of the COVID-19 lockdown. When we're dealing with commercial property, the role might well be reversed. The fact of the matter is that there are certain remedies available and certain pieces of legislation that are applicable when dealing with residential property which are not applicable when dealing with commercial property. Generally, commercial property is addressed strictly on the agreement between the parties. Under the current circumstances, we are all aware that the regulations that were published and promulgated stipulated that certain non-essential businesses were to remain closed. This automatically meant that those businesses earned no income, generated no turnover, and yet remained liable in terms of the rental agreement for the rent. Now, just recently, on the 19th of October 2019, the Honorable J. Valley once again attended to the issue of force majeure and the impossibility of performance on a contract. The Honorable Valley J. confirmed the common law position. The Honorable Valley J. also confirmed the principles contained in the 1954 case of Bailey versus Harwood. It is an established principle in South African law that legislation may result in a party claiming that they could not perform in terms of an agreement based on vis majeure, and more specifically the casus fortuitus, which would better be described as a species of the vis majeure. In the current situation, it is obvious that the regulations gave rise to a situation where shop owners were prohibited from utilizing their shop to generate any turnover, and that the landlord was also prohibited from forcing the tenant to occupy the premises. It is thus obvious that based on the regulations and in the situation that many commercial property owners find themselves, is that the tenants have not occupied the property and that occupation, beneficial occupation, has thus not been given. It is thus my opinion that based on the current situation, the tenant would not be liable to pay the landlord the monthly rent for the period which was not utilized. It is important to note that I am of the view that it would not entitle a tenant to resolve from the agreement completely, but would simply entitle the tenant to request a reduction in the amount due, in all probability be for the days which the premises were not utilized. It may well be that certain premises need to be analyzed more specifically and scrutinized very closely in order to determine whether the landlord is in fact entitled to a portion of the payment and whether the tenant is obliged to pay such payment. This would be based on the specific circumstances relating to the specific premises, in that it may be that a tenant utilizes the premises both for generating an income as well as for storage. Should it be that a certain portion of the premises is utilized for storage, then one may argue that to the extent that the tenant utilized the premises for storage, and that the tenant would have to utilize any other premises for storage in any event, then I am of the view that such portion would be payable to the landlord. As I stated in my previous broadcast, under the current situation, it is important that parties negotiate and discuss these issues with one another in order to find a solution which could be beneficial to both parties. Please also bear in mind that each specific circumstance may be unique, and one should not just accept the contents of this video as being an absolute. There are numerous issues that need to be addressed that are more technical and intricate in nature, and in order to do so and correctly provide you with advice applicable to your situation, I advise you to contact your local legal practitioner in order to present him with the full facts surrounding your specific circumstances. Should you ever require any further information or assistance, you are more than welcome to contact me. My details will follow at the end of this broadcast. Please note that it appears that many people have issues relating to other contracts. We are going to classify those contracts in one basket and probably deal with them tomorrow. Those will be issues such as deposits that were paid for accommodation, for holidays. There were certain travel arrangements were booked, wedding venues, birthday venues, services of photographers, deposits paid for those, and all those issues we will cloak together in one basket tomorrow and have a look a bit closely at them. Then another aspect which is in need of urgent address is the aspect of the employer-employee relationship, and more specifically with regards to the claiming from the unemployment fund, as well as employers that have found it necessary to compel their employees to either work shorter hours, alternatively to take their leave, their paid leave at this point, and then subsequent to that to then start taking unpaid leave. We will have a look at what the situation is regarding that aspect. So please be safe, God bless, and until we meet again.